Hi, I'm Bryant, and I'm going to answer the question, should I retitle my deed to protect my parents' house from Florida Medicaid or the nursing home? This is a common question that I get. Also, people have said things like, can I change the deed? Can I add a name on the deed? And can I gift the house? Those type of questions are all the same, should have the same legal effect. So basically what I'll do is go over the common things that you need to know to properly address this question. Is we're going to talk about the gifting rules with Medicaid, and we're going to talk about the legal issues that could be involved when you do things with a deed prior to going into a nursing home. And typically all this is helpful to have an eligible attorney watching what you're doing. Alright, so first, the answer to my question, should we change the title of the house, it should be, in most cases, a no. In many cases, when you change title, it's considered a gift. Now, there are exceptions to the rule, but the general rule is, if you change the name on a property, it is considered a gift by Medicaid. The Medicaid rules do not allow gifts. That means mom has the house, changing the title of the house to you, her son or daughter, that would be considered a gift. You got nothing in return. You didn't pay her mom cash for that property. The name change to the property, that is a gift of the value of the property. That can cause you problems down the road with Medicaid, because they have the ability to search the property records about the property your mom has. So be very, very careful with changing names on deed. Next, so you hear the problem why you shouldn't change the name of the deed before going into a nursing home, or even a couple of years before. The gifting is a problem. What you should do is involve an eligible attorney in this issue, because it's not as simple as it sounds. So first, when you change the name of property or deal with fearing that Medicaid or the nursing home will take your property, you're dealing with a couple alternative issues. First, in some cases, you don't even need to do anything, because the Medicaid laws, by natural status of the property, may exempt the real estate from being counted as an asset towards the $2,000 that your mom or dad is allowed to have. So you may not need to even do anything in many cases. But some cases where there's cash flow issues or family issues, that's when you really need to talk with an attorney and figure out what you want to do. Also, important things to note when dealing with real estate in the Medicaid nursing home context is that there's also tax issues involved, income tax issues when gifting. That could be adversely affected if you were to gift property from mom to you, in addition to the Medicaid problems. And also there can be issues with family dynamics and so forth. If there's 4 kids in the family, one child, if you gift, may be upset that they didn't get a portion of the house. So gifting is a really, really precarious method of protecting a house from Medicaid. So you should contact an eligible attorney in your area about the best way to handle the house.